job the students have done here. I have organized one of these panels, and let me tell you, it is hard. I mean, it is really hard work. And although you may not realize it, they are running on little sleep and almost entirely adrenaline. They look great, don't they? But they are at the end of a very long period of very, very of last year. And this last couple of weeks, I know has been something that has been a lot of stress and trying to get the details right and to impress. So they are really very long, hard road. I mean, although they may not realize it, they have succeeded beyond their wildest expectations because I've been here for every 1 week and I think this is the best one yet. So really, they have done a really good job. And I think they do a really good job credit to us. So they should be very proud of them. This first panel of our symposium focuses on the topic of special interest influences in judicial selection, and the students have lured an amazingly impressive group of people to be part of this discussion. We have 4 presenters for 3 papers and 2 commentators who will discuss. We'll have about 15 to 20 minutes for each presentation, and then we will have 10 minutes for comment, and we're going to have last minutes for questions. I'm going to introduce each of our presenters briefly. I cannot do justice to the time we have here to share lengthy and impressive resume. We can have one right after these national issues that we think about work with them history as scholars and academic areas. Rafael, who is our first presenter, is the James E. Campbell, Missouri Endowed Professor at the University of Missouri School of Law, where he teaches courses in employment and labor law and in labor arbitration. Professor Kelly's research does take him into empirical examination of court behavior as evidenced by his award-winning article, The Supreme Court and Diggs, which at least is dismissed and improperly branded, and empirical and institutional analysis, which was published in the Wisconsin Law Review article, and his forthcoming article, The Supreme Court and Sophisticated Use of Diggs, which is published, or to be published in the Supreme Court Economic Review. Professor Kelly co-authored both of his articles, which is co-presented today. Professor Michael Solomini is the Donald P. Claycamp Professor of Law at the University of Cincinnati College of Law, where he teaches and writes in the areas of civil procedure, federal courts, election law, and conflicts of law. Professor Solomini has published dozens of articles on various aspects of the selection and behavior of federal and state judges, focusing in particular on how the institutional differences between those selection processes do or should affect federal courts doctrine. In addition to those articles co-authored with Professor Kelly, he has participated and published in numerous symposia on various topics related to judicial behavior and judicial selection. Professors Kelly and Solomini will together be presenting their paper, Federal and State Judicial Selection in an Interest Group Perspective. Then we will have Professor Michael R. Dimino, Sr., who is an Associate Professor of Law at the Harrisburg campus of Widener University School of Law, where he teaches in the areas of constitutional law, election law, federal courts, and Supreme Court politics. He's currently a visiting Associate Professor at Florida State University College of Law. Professor Dimino's scholarship focuses on the rights of political participation and judicial selection methods, and he has published several articles on judicial selection and the relative advantages and disadvantages of merit selection in judicial elections. Professor Dimino will be presenting on the paper, We Have Met the Special Interests and We Are Today. One of my favorite titles. Roy A. Schotland is a professor at Georgetown University Law Center, teaching in the areas of administrative law, election law, and pension regulation. Professor Schotland has written extensively on issues of administrative law, campaign finance, and specifically campaign financing of elected judges. His many publications include 2 books, Campaign Financing of Elected Judges and Proposals for Campaign Finance Reform. Professor Schotland will be presenting his paper, A Plea for Reality. We also have 2 commentators today. Anthony Champagne is a professor in the School of Economic, Political, and Policy Sciences at the University of Texas at Dallas, where he teaches courses on constitutional law, civil liberties, and the judicial process. Professor Champagne has also written numerous articles, essays, and book chapters on the partisan election of state court judges and the changing politics of judicial elections over the past 25 years. In 2006, he co-authored the book, Judicial Politics in Texas, Partisanship, Money, and Politics in State Courts. And he has also testified in federal court and in legislative hearings on these topics. Epstein is the Henry Wade Rogers Professor at Northwestern University School of Law and a fellow in the American Academy of Arts and Sciences and the American Academy of Political and Social Science. Professor Epstein, who teaches classes in constitutional law, the Supreme Court, and judicial behavior, has authored, co-authored, or edited over 100 award-winning articles, essays, and books regarding the Supreme Court and lower federal courts, including the Supreme Court Compendium, The Choices Justices Make, and Advice and Consent, The Politics of Judicial Appointments. So you can see the students really have gathered an incredibly esteemed group of people, and I will let Professor Gely start with his presentation, and after everyone's done, I will come back up and field some questions.
Thank you, Fred. I do not know much, but one thing I know is that when you are in a panel with such a remarkable group of presenters and commentators, and where the next session in the program is involved and addressed by a Supreme Court justice, your best bet is to be short and get out of the way and let us. So I will be sure to do that today. Using as a starting point a 1975 article by Judge Richard Posner and Professor William Landis, our paper explored the role that interest groups play in judicial selection systems. For purposes of the presentation today, we will first briefly summarize the Landis and Posner's article and then discuss some of the implications of their model. In their article, Landis and Posner seek to explain the apparent puzzle of why a legislative body would ever agree to create an independent judiciary. Landis and Posner's answer is, in short, that it is in the interest of the legislature to do so. Landis and Posner begin with the now somewhat standard public choice story in which legislatures sell and interest groups buy legislation. The price that interest groups are willing to pay for a favorable piece of legislation depends on the value of the protection that they seek to receive, as well as on how long they believe the legislation will be in place. The legislative deal, as they call it, thus needs to include not only the substantive protection sought by the interest group, but also needs to include structure which limit the ability of future legislatures to change the law. Landis and Posner note that providing the judiciary with some degree of independence serves this purpose. To the extent that judges are not subservient to the political preferences of future legislatures, they will be more likely to interpret legislation according to the intent of the enacting legislature. In that sense, the initial legislative deal is safeguarded. Judicial selection mechanisms are a part of the judicial structure, and Landis and Posner argue are a big piece on how legislatures can create an independent judiciary. As one would imagine, the Landis and Posner article has been the subject of substantial commentary. In the paper, we discuss some of these commentaries. Today, however, I would like to skip that section and instead discuss three. First one is the definition of an interest group. The second one is the role that interest groups play in the designing of a judicial selection system. And the third one is the role that interest groups might play once the selection system is in place. I will address the first two of these topics, and Michael will discuss the last. So first, what is an interest group? Landis and Posner frequently refer to interest groups, but never fully provide a definition of the term. In some of the examples they use, they appear to have in mind what we refer as an industry-specific interest group. For example, they use the example of dairy producers asking Congress to impose a heavy tax on an alternative product, margarine. We know, however, that there are a variety of groups with interest in the judicial and legislative process, which might or might not act in the same way as industry-specific interest groups. For example, take for example the professional lawyers bar. As an interest group, lawyers might have goals that are not consistent with the establishment of an independent judiciary. To the extent that that is true, then one might expect lawyers as a group to have different preferences in terms of judicial selection systems. For example, at a very financial level, pecuniary level, lawyers might benefit from uncertainty. The less precise the law is, the more maneuvering room is there for various groups to advance new positions, creating in the process new business for lawyers. I am reminded of a lawyer's joke that I've seen in my professional responsibility class in law school, and the joke is about a lawyer in a small town whose practice was not doing too well. That is, until another lawyer moved into town, and then business bloomed for everyone. So my point is that to the extent that lawyers benefit from uncertainty, it is not clear why one would assume that the bar, as an interest group, would prefer judges to decide cases based on the intent of the enacting legislature, as Landes and Foster suggest. Instead, lawyers might prefer to have judges willing to undo the legislative deal. Having the ability to influence these judges might be in the interest of achieving some portion of the law. The second issue we discussed in the paper relates to the role that interest groups might play in quoting a phrase from Professor Epstein, one of Professor Epstein's articles, selecting the selection system. In the Landes and Posner model, interest groups appear to play no direct role in the designing of the judicial selection system. Recent scholarship, however, has begun to explore the role that interest groups play in the process of establishing a judicial selection system. Andrew Hassen, for example, has written several articles explaining the emergence of various types of selection systems as an attempt to resolve agency problems that over time develop between the public on the one hand and judges and legislatures on the other. In a very illuminating analysis of the conditions associated with legislative choices regarding judicial selection and retention mechanisms, Professor Epstein, one of our commentators and her colleagues, explored the role of politics in the enactment of selection systems. Epstein and her colleagues hypothesized that selection mechanisms associated with judicial independence will be more likely to be adopted in situations of high uncertainty in terms of the political future of those enacting the legislation, and also in terms of the political preferences of the public. Thus, by explicitly recognizing that politics matter in the process of establishing a selection mechanism, and given that interest groups care about politics, Professor Epstein's work provides a clear opening for the study of the role played by interest groups in these areas. We believe that that is an important line of future research. With that, let me then turn the floor to my colleague Michael Somolini, who will be discussing how do interest groups, or what role do interest groups play after the judicial system has been established. Thank you.
Thanks for the invitation here and to participate in this wonderful symposium. So just to pick up briefly on what Rafael said, so we were asked to consider the role of special interest or interest groups in state judicial selections. So Rafael and I thought it would be good to revisit this often cited, though sometimes not discussed very much, article by the prolific team of Landes and Posner, the independent judiciary and an interest group perspective, which, just the title of it looks related. So our paper does sort of a lot of revisiting in light of the 30 plus years since the article was published. So yes, as Rafael just explained, that they've been using interest group and what's called public choice theory, they consider the issue of why would interest groups and other institutions like just the legislature, or state legislature, why would they agree ahead of time to set up a judiciary, much less an independent one that's, at least in theory, independent of these other branches of government. So, in other words, if I can use the language of economics and public choice theory here for a little bit, that they take what's called an ex-ante perspective, knowing ahead of time how they want to do certain things, why would these institutions, why would or would not they set up a judiciary. We're not able to talk about that. One thing, as we analyze their article on the paper, one thing that in our view they don't give enough weight to is using the language again of public choice theory. They don't give enough attention to ex post factors. In other words, what once the judicial selection system is set up, how might interest groups attempt to influence the selection of judges? And perhaps somewhat curiously, the otherwise interesting and provocative article by Lance Poster says very little about that. And obviously, there's I think most people agree there's that goes on, and we seek to unpack that and talk about that in the paper. So let me just talk about two or three things, some obvious and perhaps not so obvious ways that interest groups in ex post may seek to affect the selection of judges once the system is in place. In their article and in our paper, we talk about this going on at the federal level, but due to time constraints and the purpose of this symposium, we'll talk here about the state's court. So it seems to me that there's some comments here that we should have some caution in making overly generalizing here, that there's a lot of things going on with respect to state judicial selection. It's not simply that there's more interest group activity. I mean, as there's going to be much more discussion about this later in the symposium, that interest group activity broadly defined, there's obviously a lot more of that going on. As Rafael mentioned, one of the things we explore in the paper is that when Symposium, they use the term interest groups a lot, but they don't really define quite what that means, and we argue there ought to be a broad definition of that. Perhaps Michael Dimino will talk more about that. He says we're all interest groups. We all don't quite that far necessarily, but we call for a broad definition of it. So that would mean what? That would mean political parties themselves are, yes, a form of interest groups. The bar associations are interest groups, in addition to kind of, I guess you loosely call private interest groups, the business groups, defense attorneys, plaintiffs' attorneys. Obviously, those are all, at least we view them as interest groups, even if they don't perhaps necessarily conceive themselves as such. And then there's not-for-profit interest groups like the American Judicial Society and other groups like that. So and again, this is going to be much more discussed later. Lots of data telling us that in the past 2-3 decades that there's much more activity by these various interest groups broadly defined in trying to influence the selection of judges in the 50 states under current systems, whether you're talking about the Missouri plan or like my state of Ohio, which is competitive elections, nonpartisan, putatively nonpartisan competitive elections from the Ohio Supreme Court all the way down to the small claims court and everything in between. And I'm sure there's going to be much more discussion about how these independent interest groups, apart from the political parties, I should say, are raising money and campaigning, buying TV ads and doing all these things, and plenty of evidence that this simply, wasn't occurring, certainly not at this level as late as the 1970s or early 1980s. So why is this? Why is this? Well, the number of familiar, perhaps not so familiar reasons. People often point to the types of decisions that state judges are now making, more so in the past 2 or 3 decades, as opposed to earlier controversial decisions about criminal law, tort law, the school finance, a variety of other things, and that's just attracted the attention of interest groups among others who want to have favorable policy outcomes on those sort of things. There's also evidence that, quite simply, there are more interest groups now than there were 20, 30, 40 years ago. That we have data in terms of the registration of lobbying groups and other things that tell us there are quite simply more interest groups now than there were in past decades, and they want to get things done and promote their membership and do various other things. And that's simply the greater number of those groups will at least in part explain why they're more interested in doing more state judicial elections. I mentioned earlier the caveat that in the paper we suggest that one shouldn't overstate this too much, that most of this increased activity is at the state Supreme Court level, and that there's less of it for elections and selections to the lower courts states. Moreover, the higher salience, the increased controversy of state Supreme Court and other state court elections is not due simply to increased interest group activity, although to be sure that's a large part of it. That's the scholars who have looked at this, including Professor Schotland, Professor Dimino, and other people here today, tell us that, well, let's do the other factors as well, like increased inter-party competition at the state level, and a variety of other factors that no doubt work in a synergistic way with the increased activity of interest groups. I just want to end with mentioning something that's perhaps gotten a little less attention in terms of things that interest groups do, and that's the filing of friend of the court briefs and Curry briefs, and lots of evidence that at the U.S. Supreme Court level and at state courts that interest groups, broadly defined, are increasingly filing friend of the court briefs on a whole variety of cases. Interestingly, to us at least, they have done that, not surprisingly, in cases, litigation that actually affects or involves state judicial selection. So there are a number of examples of this, just focusing at the U.S. Supreme Court itself. Just to quickly mention some cases. Chisholm versus Romer from 1991 involved whether the Voting Rights Act applied to state judicial elections. There was a case, I believe, the same year called Gregory versus Ashcroft from the great state of Missouri that involved the issue of how the Age Discrimination Act applied to the age limit for judges. And I believe Justice O'Connor wrote the majority opinion in that case, if I'm not mistaken. But I wanted to mention two other, a little more recent cases that involve interest group activity through amicus briefs. And that's the Republican Party of Minnesota versus White case from 2002, which I'm sure will be discussed by other participants today. That had, at least to our mind, has some strange bedfellows, or interesting bedfellows when it comes to amicus briefs. Among other interesting things in that case, you had the ACLU, the American Civil Liberties Union, and the U.S. Chamber of Commerce, two interest groups that you usually don't see on the same side, or at least it seems to me they were on the same side of that case, supporting the Republican Party, who's, as you know, successfully challenged the campaign restrictions found there. Likewise, in the Caperton case from West Virginia, currently pending in the U.S. Supreme Court, a number of amicus briefs have been filed there. Again, arguably some at least interesting fellows, not necessarily strange ones, that you have the Brennan Center, Justice at Stake, and other interest groups who are arguing on behalf of Caperton for higher refusal standards. A variety of corporations have filed briefs in favor of that. As well. So again, it's just another example of how, in our view, there's a lot of activity. We deliberately, in our paper, as when Symposium, were largely descriptive, and we're deliberately not taking too much of a normative view here about what, if anything, does this mean? Is this good or bad? There's all this increased interest in group activity, and we're going to leave that issue, the more normative issue, to Professor Dimino, Schotland, and others to take a look at. Thank you.
Thank you, Dean, Professor Wells, especially the Missouri Law Review. Thank you for the invitation to speak today. Thank you for placing me on such a wonderful panel. Thank you to all of you for coming. My purpose here is to argue that the exercise of judicial power will advantage certain interests at the expense of others, regardless of the method of judicial selection a particular state uses. Accordingly, we should be careful that attempts to control the influence of special interests do not, in fact, simply advantage one set of special interests. I have two major points. First, because there is no such thing as a general interest, it makes no sense to speak of special interests. Second, judicial decisions make policy. In so doing, they benefit certain interests at the expense of others, whether judges are selected by elections, appointments, or some hybrid system. And so, it should not be surprising that politics pervades the choice of judges under every system used or considered today. No selection system may be capable of eliminating the power of interest groups, but the selection system may determine which of those interests are benefited. As a result, debates about judicial selection should be viewed skeptically and are far more likely to reflect disagreements about policy than about the appropriate selection methods to ensure judicial quality. The term special interest is a disparaging one because it implies a comparison with something else, a general interest. But it is elementary political science that there is no general interest. No policy is optimal for all segments of society, and therefore the job of policymakers is to choose between potential benefits and between potential beneficiaries. Is a town to zone land for parks or business? Build schools, lower taxes, or increase welfare benefits? Roads or public transportation? It simply gets us nowhere to label certain of these policies the work of special interests. Rather, we use the label as a way of dismissing those policies that we've already concluded are unwise. The very concept of the special interest, therefore, is purely rhetorical and is incoherent and useless as a tool of logical persuasion. The interests benefited and harmed by judicially made public policy are just as special as those benefited and harmed by legislatively made policy. A court's adoption of strict liability or negligence, its choice between strict and forgiving readings of the statute of limitations, and its interpretation of the takings clause, for example, all result in benefits and harms to identifiable portions of society. In such circumstances, the judicial process has benefited some interests over others, regardless of the particular outcome in that case. Accordingly, the relevant question is not whether the interests favored by judicial elections are special, but whether any system of selecting judges can avoid the risk of giving certain interests an advantage in the judiciary's policy making. No such system is possible. Critics of elections, therefore, should have to explain why a system that favors their interests is preferable to one that favors the interests preferred by voters. Now, everybody understands that judges and courts make policy, and therefore everybody understands that the results of court decisions advantage certain interests. The problem, according to those who decry special interest influence, is that the interest groups not only benefit from, but seek to shape judicial decisions. Thus, while critics may admit that the phrase special interests is misleading and incapable of neutral definition, their essential point remains. Judges should not be influenced by forces outside of the law, whether those interests are special or otherwise, because judges should not be politically vulnerable for being legally right. Judicial independence, however, allows judges not only to enforce long-established or clear rules of law, but also to exercise discretion in the interpretation of ambiguous law. In virtually every state Supreme Court decision provoking a dissent, and in a significant percentage of unanimous cases as well, reasonable jurists can disagree as to the appropriate outcome, with neither majority or dissent being legally wrong. In such cases, and where judicial decisions have a great impact upon public policy, the people's ability to affect the membership of courts through elections is most beneficial, and the insulation of those courts from public influence is least defensible. Indeed, cases where no reasonable jurist could disagree are virtually non-existent at the level of state Supreme Courts, notwithstanding some critics' protests that lawmaking by judges comprises a minor portion of the document. Accordingly, a critique of elections stressing judges' mechanical law-applying function assumes a simplistic fourth-grade civics ideal of the judicial process, which portrays judicial decisions as virtually unaffecting and unaffected by political consequence or ideology. Of course, any particular court decides very few cases dealing with the most divisive public issues, such as abortion, affirmative action, and the right to die, for example. And some of those cases involve statutory interpretation rather than bringing a judge's own judgment to bear on an interpretation of a constitutional phrase as vague as the 8th Amendment or the 5th or 14th Amendment's due process clause. However, decisions that don't make headlines still make policy. Consider implied private rights of action, for example. And as rare as it is for a court to decide a crucial case about school funding or the death penalty, those cases may be viewed as the most important ones a court hears. It is a curious defense of judicial independence to say that society should have to tolerate unrepresentative judicial lawmaking concerning the legal questions that matter most, so that judges can be free to reach proper conclusions with respect to the humdrum. Moreover, as anyone who has read a statutory interpretation case can attest, the meaning that a judge gives to statutory text can vary tremendously depending on the judge's view of the potential policy consequences. Further, judges' common law-making power is not subject even to the restraints that judges face in interpreting statutes. Thus, state Supreme Courts, which exercise the power to shape common law far more than do the federal courts, indisputably make policy based on their views of good policy. Now, interest groups have long recognized courts' policy-making capabilities and have sought to influence decisions of both elected and appointed courts for decades. Such influence is relatively uncontroversial when groups such as the NAACP, NRA, ACLU, etc. file amicus briefs, fund litigation, offer advice to litigants, uncover potential plaintiffs, or develop their own testimony. Interest group influence becomes controversial, or more controversial anyway, when the groups attempt to influence judicial decisions by influencing the selection of the judges who make them. And there can be no doubt that interest groups do, in fact, seek to affect judicial selection. But it is important to recognize that such influence occurs regardless of the method of judicial selection. In elective states, groups such as the Chamber of Commerce and the Trial Lawyers Association advertise for the election of their favorite candidates. It only makes sense for them to do so, given the policy differences that can result from the selection of different judges. In our pluralist system, individuals' interests are represented by groups. And there is nothing per se wrong with interest groups' attempts to influence elections. If individuals can engage in electoral advocacy, then groups should be able to do so as well. In federal-style appointed systems, interest groups lobby the official responsible for selecting the nominee, as well as the body responsible for confirming the selection. In states using the Missouri plan, interest groups are able to do both. They lobby for the appointment of judges with favorable philosophies, and they lobby the electorate to retain them and reject others. As we might expect, therefore, there is no evidence that the Missouri plan eliminates threats to judicial independence. The dispute about interest group influence is really only the perennial one about balancing independence and accountability. But judges' accountability to the people is in tension with, if not opposed to, the judicial function of deciding cases on the basis of the law and the facts, irrespective of public opinion. In other words, while states require judges to stand for re-election or retention to ensure that the judges do not vary too much from public opinion, judges must, if they are to be faithful to their offices, rule against public opinion when the law requires it. To admit that certain selection systems may lead to bad consequences, however, does not mean that alternative systems are flawless. Rather, each system has its problems, and states must determine where the advantages and disadvantages of each matter most. That is why I have argued that states evaluating their judicial selection systems should consider appointing lower court judges and electing high court judges to lengthy, non-renewable terms. The pressure on judges to decide cases consistently with public opinion, rather than with the law, may be too great in a system where judges' jobs depend on someone else's evaluation of their decision. Making terms non-renewable means there should be no reselection, whether by appointment, election, or the uncontested elections identified with the Missouri Plan. My dissatisfaction with reselection systems, however, says nothing about the kind of system we should employ for the initial selection of judges. As noted earlier, judges on state Supreme Courts exercise a wide amount of discretion in interpreting statutes and constitutions, and especially in shaping the common law. Those decisions affect policy, and judges exercise their discretion based in part on their own views of wise policy. Accordingly, states have an interest in ensuring that those policies are acceptable to the public, rather than merely embodying the preferences of unrepresented judges. Interest groups can aid in communicating and motivating public opinion, and therefore the involvement of groups in the process of judicial selection can help to ensure that a state's judges have philosophies consonant with the dominant opinion in that state. And where interest group involvement is limited to judges' initial selection, there is less risk of the harms caused when sitting judges fear antagonizing groups that could retaliate by opposing their retention efforts. Interest groups seeking to influence elections must compete with every other group that has the resources, the people, and the inclination to become involved. The resulting marketplace of ideas might be distasteful to some who believe that judges should be treated differently from politicians. But it allows all interested groups to express their opinions. The influence of each group depends in part on resources, but also on the degree to which the voters find the group's arguments persuasive. The danger in other systems is not only that groups will be able to influence the process, they will, and there too their influence will be due in part to their resources, but also that certain groups will be granted disproportionate influence, with elites and those already with access to government determining the appropriate balance of power between groups. Critics of elections note the potential for campaign donors, party leaders, and others to be repaid by favorable decisions while on the bench. It is certainly possible that these supporters might be the recipients of improperly favorable rulings during the beneficiary's term of office. Two notes of caution are in order, however. First, most of the influence that such a supporter would carry would be due to the implicit effect of a decision on the supporter's willingness to back the judge in his or her attempt to retain office. If there is no chance of reselection, then threats of withdrawn support for an effort to retain the office lose their strength. Second, it is not just elections that yield debts to persons and interests who are influential in placing a judge on the bench. Indeed, states' adoption of judicial election systems was motivated in part by a desire to free judges from the influence of the political branches and political officials who would otherwise have been responsible for the judge's appointment. Supporters of judicial elections reasoned that it was better to have a judge responsible to the electorate than to have the judge beholden to individuals in government. Now, reasonable people can disagree with the political philosophy that seeks to make judges reflective of the will of the voting public. But one cannot seriously contend that appointive systems take politics out of judicial selection. If the people are not permitted to use political considerations directly in judicial elections, then the people's representatives will use political considerations in judicial appointments. Eliminating elections, therefore, will do little to lessen the influence of interest groups and may, in fact, increase their power. Presidents have often made political considerations paramount when selecting judges. And in a pluralist society, politics means pleasing or placating pressure groups. President Obama, following a long tradition, has declared his intention to use his judicial appointments as a way of advancing his political vision and the visions of interest groups that support it. He has stated that in selecting judges, he will look for, quote, somebody who's got the heart, the empathy to recognize what it's like to be a young teenage mom, the empathy to understand what it's like to be poor, or African American, or gay, or disabled, or old, unquote. If there is one thing that this litany of interest groups makes clear, it is that interest group power in judicial selection is not restricted to judicial elections. Indeed, elections may be less likely than appointments to be influenced by certain interests. Reform models based on the Missouri Plan often institutionalize the power of interest groups, reserving power on judicial nominating commissions for representatives of various groups, particularly the organized bar. For example, almost all states using nominating commissions reserve places on the commissions for lawyers. In one state, Kansas, allows lawyers to select the majority of the commissioners. Not only does the composition of the commissions give lawyers disproportionate influence over judicial policy, but the choice of those lawyer commissioners is often left to bar associations or bar presidents, rather than to elected officials. Ironically, involvement of the bar is often portrayed as a solution to the problem of interest group influence, rather than as part of the problem. 11 states, using nominating commissions, have a provision for ensuring that either the applicants or the commissioners, or both, are in some matters diverse. Now, I'm not arguing that minorities, women, lawyers, or any other interest should be denied access to the commissions or denied access to places on the bench. My point, rather, is that each group is an interest, a special interest, and that manipulating the membership of the commissions or the characteristics of the applicant is a less visible way of achieving policy results that might not be politically possible in elections. Reformers champion the ability of appointments to increase the number of minorities and women on the bench, although such a defense of appointments is a transparent admission that the fault that reformers find with elections is not that elections can be influenced by interests, but that the wrong interests too often prevail. The lesson for those of us who study judicial selection is to be careful of our own motives and suspicious of the motives of anyone who urges that the public is incapable of choosing its own public officials. Arguments by reformers promise that eliminating judicial elections will result in a judiciary that is more independent, but it is surely not coincidental that reformers often push for unpopular policies in areas such as criminal law and death penalty, punitive damages, and the establishment clause that would be resisted by the voters. Reform groups seek to alter rules about judicial selection not to purify the judiciary, but to produce a judiciary that is more amenable to the reform group's favorite policies. In other words, the reform groups are special interests.
Thank you, especially these law review amazing people, for the privilege and pleasure of joining you in the best possible state, surely, to talk about judicial selection. For me, after 25 years of involvement in judicial elections and 4 weeks after retiring from teaching, not, I hope, from continued involvement, this is a special opportunity to share views, air questions, consider the ever-evolving changes and challenges, and speak bluntly on a few points. I treasure the friendships I've built with others similarly involved. I hope my comments, some of which may seem unrestrained, are taken in the spirit that underlies them. We have two excellent commentators, but allow me a few comments about the two papers. They focus on how significant are interest groups. Don't we applaud that significance? If interest groups were not significant, would this be a democracy? Like democracy, interest group significance isn't 100%. 4 sentences about Michael Dimino's paper. He opens saying twice, as you just heard, there is no such thing as a general interest. Overstatement, no? Unless general interest includes every human on the planet, surely there's a general interest in stopping more 9/11s. There was a general interest in stopping the Nazis. There are general interests in convicting criminals, getting competent judges, promoting fair trials. Dimino's opening overstatement doesn't matter, but his constant overstatement here and elsewhere that judges and legislators both make law, so elections for them should be the same. That is not only damaging if it got anywhere, which I guess, is destructive. To deny the differences between selecting judges and selecting other officials is to deny the differences between the judge's job and the jobs of other elected officials, which is to deny the rule of law. And for our nation, is to deny the difference between the branches. That is, to deny a bedrock of our Republican form of government. I hope we won't hold back today. A leading Shakespeare scholar in his final book, wrote of a tradition whereby formerly lively minds produce in old age unduly mellow books. Mellow is not my middle name. But we all share key values, including how much we care about state courts. And if your time and mood permit, suggesting improvements in my paper, which will become an article in this outstanding law review, I appreciate any reactions either to that or to what I say. Allow me 4 points right now. First, in the words of the long ago unnamed Texas CJ, no judicial selection system is worth a damn. Whatever one says about the federal courts, our state court struggles bear out that statement. Every system does have serious problems. I believe we today can be most productive by noting steps that will reduce the problems. Second, I will note facts about how many of our state judges face elections and what change we've seen over the last century, or to be more precise, as I'll say why, 103 years. Also, the fact that for the last generation, change in selection systems has been talked about. Indeed, for almost 200 years, it has been the endless debate. But over the last generation, all but zero action. Third, I'll touch on why judicial elections are different and should be different, because the judge's job is so different. Fourth, the liveliest current problem being argued this coming Tuesday at the High Court, they hear a novel suggestion for procedure on recusal in high courts. As for other problems about judicial elections, I note several steps in my paper at pages 14 to 17. The paper closes naming and honoring 15 chiefs, with only Missouri having 2 honorees, former Chief Justice Mike Wolf and Ray Price, both a former and in a few months, again, Chief Justice. Let there be no doubt that I think the world of Laura Stiff, starting with our work together the first time in 1975, and I hugely admired her performance as chief. But Wolf and Price give me perfect bipartisan balance. The 15 chiefs I name in the closing pages of the paper get my Godiva awards, which I explain on page 18. Entirely separate from all that, for Justice O'Connor, I have a long footnote, the kind of thing only a professor would do, with a message to the Justice in footnote 5 of the pages. Let me just say 3 words to you now, if I may. Professor. 39 states chosen judicial elections. Whether you like judicial elections or not, do not distort the state's choice. First of all, I hope we're all happy that states can make choices. I hope we all agree that having a federal system is one of our greatest strengths. But one cannot fall into the mantra, an election is an election, because the elective states put into their constitutions at the same time provisions that preserve the fundamental differences between judges and other elected officials. Now, how many judges face elections? Well, The Economist magazine wrote this 3 years ago. Back in 1906, Roscoe Pound started a campaign to have judges appointed in a historic address to the ABA. When he spoke, according to the Economist, when he spoke, 8 in 10 American judges stood for election. Today, the figure is higher. If we continue at the rate of change of the last 103 years on selection systems, we need only another 160 years to end contestable elections for fellow judges, and for trial judges, only 770. Now, the array of state constitutional provisions that came with the choice of elections. For example, every elective state gives judges terms of office longer, in many states inconceivably longer, than any other elected official. And the constitutions have an array of other provisions inconceivable for other elected officials, like requiring experience or training, or requiring resigned run for any non-judicial elective office. The state constitutions include such provisions because the judges' jobs are so different from the other elected officials. And in my paper at pages 6 and 7, I set out key differences, astonished to realize as I looked at it on the plane here that I had somehow left out what I would say is the most important difference of all. Judges' decisions have direct impact on one or a very few individuals, a power and a responsibility that is unique except for the very, very rare exercises of executive pardons. Given the job of a judge, think of the characteristics, the personality traits that make a person suitable for the bench. The judge, or would-be judge, does not pursue popularity as do other elected officials, who constantly, starting probably in preschool, do what they can do to be popular. In an article out this week at the Denver Law Review, a non-live print symposium opened, as all symposia are on these subjects, by Justice O'Connor. I present findings on the judicial personality from a presiding judge in California who has done national psychological surveys of judges. If elective judges have to go through no-holds-barred campaigns to get on the bench or to stay there, we will lose many people who would be fine judges. Now, what might we do to reduce the problems in judicial campaigns? My pages 14 to 17 offer several specifics, and earlier I deal with the one I want to get into now, recusal, which 3 years ago a Ninth Circuit judge called the topic du jour. Recusal is hot right now, like in a large piece in yesterday's USA Today, because on Tuesday the Supremes will hear argument in Caperton, a case about a West Virginia justice's denial of a motion that he withdraw. He is now their Chief Justice. But recusal has been hot for several years, though it's now hot-asked, because of judicial election campaigns, which have had two developments. A slight, at least so far, only a slight, although be more, increase in the nastiness and noisiness of judicial elections, and a big increase in the funds in judicial elections, both the campaigns themselves and non-party, non-candidate spending. If anybody is so inclined, as poor Lee Epstein has just done to read the briefs in paper, starting with Ted Olson's unsurprisingly excellent one for petitioners, and the usual posse of Mikey on both sides. Aren't we lucky to live in an era when the court has so many friends? My footnote 23 in the paper comments on some of the briefs, sending bouquets to some and sending brickbats to others, not naming, of course. Well, since we do have available briefs and recent articles in our site, here I would offer only one point, a suggested procedure for recusal motions in high courts. Now, context. Many states have fine, even exemplary procedures for trial court judges' recusal. From, I think it's 19 states, peremptory strike challenges by litigants, just the way you can knock out some jurors, you can knock out one judge, to automatically sending all recusal motions to an administrative judge, or, as in Ohio, to the Chief Justice. However, at many appellate courts and at even more high courts, recusal cries for procedures that can assure fairness, protect public confidence, and, to put it simply, work effectively and smoothly. No small challenge in a multi-member court. Many of these courts, especially the high courts, have no procedure other than leaving the recusal decision entirely to the judge targeted by a motion. Here's a suggested procedure. For high courts, perhaps also intermediate appellates, we should adopt a version of the NFL's Rooney Rule. That rule requires teams, when interviewing for coaching positions, to include at least one minority prospect. The rule was adopted largely because of the special status of the Pittsburgh Steelers Rooney family. The rule has been a signal success. All the rule requires is a conversation, a chance to talk, a chance to listen. If a court leaves recusal decisions to a justice individually, then before the justice makes a decision, she or he should have, and I would say must have, a conversation with a panel of 3 court-appointed wise souls, probably a mix of retired, or any one category, retired judges, retired lawyers, retired legal academics, with rotating terms of, say, 2 years. The consultation, which could be a conference call, conversation would be entirely confidential, permanently. One might provide that no consultation is needed if the justice decides to grant the recusal motion, or one might call for consultation even then to promote dialogue, uniformity, and to protect the duty to sit. Also, one might add some requirement for the justice to write an opinion. One might get into other steps. For example, how, if there is a recusal, how is the replacement selected? What process is there for that? I close with people's appreciation to everyone who cares about courts and justice and the people who work to keep our state courts strong. Thank you.
Thank you for having me here as well. I'd like to narrow the discussion a bit and just discuss one part of this issue about interest groups. And that is the role of political parties and interest groups in maintaining our changing state judicial selection systems. For a moment at least, let's just pass up the debate over whether judicial selection systems should be changed and just go to the main point, which is if we're going to go from A to B, if we're going to change a state system of judicial selection, what must be done? How do you get from a judicial election system to a merit selection system? And I say that because that's the way the pattern's been. We've always gone from judicial elections to merit selection. The one possible exception may be coming up very shortly in Tennessee, where we may go from merit selection to judicial election. But let me start with what both papers mention, and that is the most important group that must be considered in changing the state system of judicial selection. It's the bar. And as they point out, the bar is not a monolithic institution. In battles over state judiciaries, the segments of the bar that are most involved, because they have the most at stake, are lawyers who handle civil cases. These interests within the bar have proven mortal enemies in backing opposing candidates in judicial elections throughout much of the country. The Salamini paper is correct when he mentions that the death penalty has been an issue in judicial races. Professor Dimino is correct in saying that crime is an important issue. But the fact of the matter is the driving force in all high-profile judicial elections over the past quarter century has been tort law. To a considerable degree, issues like the death penalty or crime have merely been tools by interest groups interested in tort law to mobilize the voters for or against particular judicial candidates. So it's these two segments of the bar, with the defense bar aligned with business and professional groups, and the plaintiff's bar aligned with labor unions, that have been at the core of judicial election battles, as well as judicial selection battles. Lawyers are such an important interest in judicial selection debates that lawyers get a guaranteed voice in the selection of a state's judges under the Missouri plan. The issue of which type of lawyer is getting that voice is really a very big issue, and is a key factor in determining whether the bar, or at least key segments of the bar, will back merit selection. Another interest not mentioned in the presentations that usually has a reserved place on merit selection commissions is judges. We usually don't think of judges as a separate interest group, but they certainly are in the area of judicial selection. Judges who have been elected tend to be quite pleased with the current system of judicial selection. It must be good. It elected them. That changes, of course, if partisan sweeps begin to occur or if judges' positions are threatened. But to gain support for a change in the system of selection, you have to convince judges that merit selection is in their interest. In recent years, and Professor Dimino points this out, minority groups, Latino groups in the Southwest and African American groups in the South and Midwest, have been interested in increasing the numbers of minority judges. And as a result, these groups have initially used litigation or the threat of litigation, in which they have argued that judicial election districts need to be designed to increase the electoral strength of minorities. And these groups have been successful in getting judicial subdistricting in states such as Illinois, Louisiana, and Mississippi. But they're not always successful. Nevertheless, minority groups and their lawyers remain distrustful of merit selection because they fear it will not bring about as many minority judges as would judicial subdistricting. Business and professional groups are often aligned against labor unions for judicial election campaigns, with business and professional groups backing judicial candidates with a tort reform agenda and labor unions supporting judicial candidates who are often backed by plaintiffs' lawyers and supporting an anti-tort reform agenda. These groups are always seen in battles in judicial elections, and they're also in the battles over judicial selection reforms. How do you affect those interests when you change a system of selection? How do you get their support in changing a system of selection? Along with these key interest groups, Salamini points out that you cannot ignore the importance of the political parties. In general, the political parties benefit from judicial elections. Judicial elections provide the parties with a stable of offices that will be held largely due to party labor, and judicial candidates provide a source of party activists and campaign workers. parties may well be expected to oppose a change to an appointive system that will deprive the party of offices as well as important party activists. So to change a system of judicial selection in a state, a political coalition has to be constructed that is sufficiently strong to win legislative approval for a constitutional amendment that then must be submitted to the voters, where of course the losers in the legislative struggle over the constitutional amendment have a second chance to defeat the proposal. And I think it's an important point to emphasize there will always be losers. There will always be important interests who can fight back in that second chance and fight back with effective sound bites, such as they're taking away your right to vote. With key players in this battle being the political parties, business and professional groups, minority groups, labor unions, the plaintiffs' bar, the defense bar, judges, as well as random groups that may see their interests affected when it comes to changing the system of judicial selection. Well, it's just a massive undertaking to bring about change. Several years ago, I was on a committee appointed by the Lieutenant Governor of Texas, Bob Bullock, to come up with recommendations to change the system of selection in Texas. And we were in a meeting room, and one of the state senators started talking about merit selection. And one of the other state senators interrupted him and said, "What's in it for me?" And of course, what he was saying was, what will merit selection do to the interest group that he was representing? Actually, that's the key question. That is the basic job in every state that is considering judicial selection reform. Satisfactorily answering that question. What's in it for me? And doing it to a sufficiently large enough coalition that the proposed amendment can be adopted. It's not an impossible task. The politics of judicial selection is dynamic. Political interests can and do change. The important point, I think, is, and it's often overlooked, there are opportune moments that allow for new political coalitions to form. In Oklahoma, for example, a number of years ago, a judicial scandal created that opportunity for change. However, opportunities for major transformations in the system of judicial selection are rare events. And given the difficulties of putting together a new political coalition of the political parties and interest groups, I think Professor Schotland's argument has much to commend it. And to me, what his argument basically is this. Resources are best spent on incremental changes within the system of judicial selection rather than dynamic and systemic changes in the system. Thank you.
I'm a political scientist by training, and I'm always so amazed when I come to these law conferences how kind and nice the commentators are. And sort of genteel, you know. They'll say the papers are wonderful, even if they don't think they're so wonderful. And they'll say how much they learned, even if maybe they didn't learn so much. I have to tell you, I don't have to stretch the truth here in the interest of collegiality. I thought the papers as a set were just wonderful, and I did in fact learn a lot. There were just some terrific ideas here, and it may not surprise you to know that I think the next step for many of these papers would be to collect some data to illuminate some of the ideas. And let me just provide a few examples from each of the papers. I'm going to start with Professor Schotland's paper, which really is quite a fascinating article. I was especially interested, and he emphasized this in his talk, about his proposals and the many proposals in the Caperton briefs about this, quote, thorny issue of recusal. What I wonder about is adopting any of these policies. Some of them are rather dramatic, like constitutionalizing and nationalizing recusal policies. I wonder adopting them without answers to this very basic but hard question: do campaign contributions actually influence the votes of judges? Now, I wondered whether we had any evidence on this, and that's why, and I told Professor Schotland this last night, I went to the Capers in Greece and I read all of them to try to see what kinds of evidence was out there that campaign contributions actually influence the votes of judges. I found 3 pieces of evidence. One, an investigation that was published in the New York Times, conducted by New York Times reporters, a study by an advocacy group in Texas, and a discredited analysis published in the Tulane Law Review, a student-edited publication, no offense to the law review. None of these studies would pass peer review. I think this is especially problematic because looking at whether campaign contributions influence votes is really, really tough for the obvious problem that interest groups or firms may be contributing to candidates who agree with them to start with. So when a judge casts a vote, is that vote reflecting the judge's own view of the right answer or the firm's view of the right answer? Disentangling these things is very difficult, but it's not impossible. Political scientists have been doing this for years in studying the extent to which campaign contributions affect members of Congress and how they vote. And so what I would like to see is some skilled researchers to come into this area and to provide some answers before we adopt some fairly drastic policies concerning recusals, especially at the state Supreme Court level. Professor Dimino's paper is also a very interesting paper. He talked about in his presentation, as well as in the paper, about his vision of how to select state Supreme Court justices. I think it would go something like this, and you can correct me if I'm wrong, that there would be an initial election followed by a non-renewable term, a lengthy non-renewable term, so there would be no re-election or no retention. I am not going to get into between Professor Dimino and Schotland on the initial selection here. They can fight that out. I do think the idea of a non-renewable term is a good one, and I confess that I did propose this myself to a group of Chief Justices last year, and they actually, some of them actually liked the proposal. I do think, Professor Dimino, that you and I both need some more evidence in support of this idea. One critique, of course, is that even with lengthy terms, judges may not be ready to retire at the end of their term. You can think about a judge who's appointed at the age of 45 and has a 15-year term and 60 years old. They may have 5, 10, 15, if you're Justice Stevens, 30 years left in the workforce, which of course opens up the possibility that one's ambitions after they serve could affect decision-making while they're on the bench. What we need here, I think, are data on terms, how long people serve now, ages of retirement, and we can also, of course, look to Europe, where many of the constitutional courts in Europe do use one non-renewable term. How is it working there? They have been in effect for a while. We could take a look. So I think I like the idea. It's very intuitively appealing to me, but I think we need some more work before formally trying to propose it. As far as Michael and Rafael's paper goes, it's another very interesting, very thought-provoking paper. I spent quite a bit of time on it. They have some a tentative idea, and properly qualified, I think, in the paper, is that interest groups have increased the politics, the politicalization of both federal and state selections of judges. This, again, is an eminently testable idea, and some people have actually done it for the Supreme Court. They've looked at the idea that the board nomination, which of course brought out scores and scores of interest groups, were ever changed and politicize the process of selecting Supreme Court justices. There's some evidence of this. After the Bork nomination, ideology of the judge, the nominee, became paramount consideration for senators. On the other hand, there's support for the idea that this politicization of Supreme Court nominations started decades ago, 3 decades ago, before the Bork nomination, with Brown versus the Board of Education in the 1950s. You started to see ideology playing a greater and greater role in Supreme Court appointments. Robert Bork said this himself. Robert Bork thought that the court, and you all say this in your paper as well, contributed to the politicization of the process. I would like to see studies of the state courts along these lines. I think that they could be equally illuminating of the processes of selection there as well. So thank you all for writing a very thought-provoking set of papers.
We have a little over 10 minutes for questions. I hope there are many, so I will take whatever questions there might be. All right. Professor Ware?
Yeah, my name is Steve Ware at the University of Kansas. I just want to quickly add to Professor Epstein's point about empirical data on the effect of campaign contributions. I did a study 10 years ago on Alabama Supreme Court campaign contributions and found a remarkable correlation between where the justices got their money and how they ruled in arbitration cases. Did they rule for the business desire to enforce arbitration clauses, or for the plaintiff's lawyer's desire not to enforce arbitration clauses? Very much correlated with where they got their money. But I concluded with the same point Professor Epstein made, which is you don't know whether the money is causing outcomes or if the justices already had those kind of views and the money was just following the views. But there is a recent paper in the Duke Law Journal, I don't know if you've seen it.
I've seen it.
And so that with the regression analysis and all the social science bells and whistles may make some progress on that issue.
So can you introduce yourself?
Alan Tarr at Rutgers University. As I listened to Professor Schotland and Professor Dimino, they're both talking about political courts or non-political courts. Professor Schotland's emphasizing the process by which judges make their decisions. Professor Dimino's emphasizing the outcomes in terms of real-world consequences of those decisions. In terms of designing the system, which is more important?
We're not going to change the process of, for example, barring ex parte contacts, are we? Or requiring hearings before one decides to affect somebody's person or property? That is, it's an excellent question, except I don't know where it goes.
I mean, even if a judge decides based on his or her best understanding of the law, there are political consequences to those decisions.
Yes.
And is that what should be foremost as we design the system?
Our whole view of the leeway that judges have in decisions is so appallingly, overwhelmingly distorted by the U.S. Supreme Court's high visibility decisions, which is a minor part of their docket. Justices of the peace, before they put on $5 fines, do not think about Roe and Wade. What I'm trying to say in caricature is that the overwhelming bulk of dockets, certainly at the trial level, and even at the high court level in states, or for that matter, federal courts of appeals, the number of decisions where there's high leeway is incredibly low. There was a wonderful article some years back by Harry Edwards in the D.C. Circuit. 3 categories of decisions. Clear decisions, the ones in which all the judges are going to agree. And I think he put that around 50-60%. All but clear decisions. No, he called it easy decisions, where they don't all agree right off the bat, but they're almost always going to end up together, or there'll be only one not hot dissent. And then tough decisions, which he put around 5%. That's the D.C. Circuit. which is second only to the U.S. Supreme Court in the difficulty of the cases they get. So I think the big thing about judges' decisions is distortion of how much leeway they have.
If I may, I think the direct answer to your question is that it depends on whether you focus on the independence or the accountability half of the dispute. If you're concerned with promoting judicial independence, you're probably going to focus on process because we see the goal of independence as providing a benefit to the particular litigants who are bringing a case. If you come at it from an accountability perspective where the major impetus is democratic lawmaking, allowing the public to have some influence on the resulting policies, then you're going to be considering the outcomes of judicial decisions. Now, with regard to whether the U.S. Supreme Court distorts our analysis, I'm sure it does to some extent because of the Supreme Court's visibility. But it's important to keep apart the difference between what I'm advocating, more elections, more accountability, more public involvement in the selection of state Supreme Court justices, as opposed to justices of the peace. All of our discussions about judicial selection are going to balance, to one extent or another, independence and accountability. And it may certainly be, it's certainly my view, that balance tips in favor of independence when we're talking about those judges who have such minimal discretionary authority as justices of the peace. They don't have zero discretionary authority, and certainly their decisions as to whether to impose jail time or probation as to a certain class of offenders can create policy consequences. But I think overall, the discretion is probably limited enough that appointments is an appropriate way of selecting judges that fill those slots. But to say that because most judges or most trial judges have a minimal amount of discretion says nothing about the level of discretion that a state Supreme Court justice has, which is great indeed, and may certainly be greater than the D.C. Circuit or any other federal court of appeals, which is designed, which is not charged with making law in any grand sense, from the way that a state Supreme Court is charged with making the contract.
Yeah, I have a question actually for Professor Champagne. You remarked that the tort bar is the main player in these judicial elections, and I inferred from your comments, and I may have wrongly inferred, that you saw this as a sort of equal battle between the plaintiff's bar and the defense bar. And that strikes me as counterintuitive in that the plaintiff's bar would have, it seems to me, a much greater stake in getting their judges selected in that their compensation depends on verdicts, whereas the defense bar's compensation depends on the number of hours they work, which may actually increase if you get pro plaintiff judges. In addition, from my own law practice, it seems to me that plaintiff's lawyers tend to work primarily in state courts almost exclusively, and the defense bar did much more of its work in federal courts as well, so they have such a large stake in the state courts. And so I wonder, first of all, did I correctly infer that you perceive this to be a balanced contest between the plaintiffs and defense tort bars? And if so, do you have any evidence for that?
Actually, no, I do not. I do not see it as an equal balance. Now, what is interesting about this, if I can refer to my own experience in Texas, a number of years ago, the plaintiff's bar was sort of overwhelming Texas Supreme Court races with money. And it took a few years for the defense bar, working with the business and professional community, to decide, well, we can do that too. And when that happened, suddenly it was the defense bar working with with the business and professional community in Texas that began to overwhelm judicial races. So I think one thing that's very important to keep in mind about this politics of judicial selection is it really is a dynamic process. One side can be way ahead in the process at one point in time. A few years later, the other side can come on strong and just overwhelm the other side.
Yes, my name is Andrew Henderson. I'm from Dimino here at the University of Missouri. First, I'd like to thank all of you, each of you individually, I think it's a memorable day for the law school, and certainly a good day for Missouri law and its future judge retention system. My question is, Professor Mulling and Gely, in your article you mentioned that Congress basically banned in the Senate confirming hearings lobbyist groups from testifying or interest groups from testifying. It went on to say that that it wasn't that effective because basically they started lobbying the senators. If we were to do an appointment in Missouri, what additional steps would you take to make sure that the interest groups really were affecting such processes?
Okay, well, just briefly, our understanding is that for the lower federal court selection, not Supreme Court selection, but for lower federal court selection, that back in the 1990s at some point, indeed, that interest groups were prohibited from formally appearing at confirmation hearings. They could submit statements and do other things, as you said, and our understanding is that that's continuing on to the present day for lower federal court judges. Your question is, well, how might that apply at the state level, particularly in the Missouri planned arena? And I'll have to confess here, I'm not quite I'm going to have to leave it to other people to talk about with more precise detail about that. Our interest groups broadly defined. It comes definitionally, what precisely do we mean by interest groups? The Bar Association, if you consider them an interest group, they already have a heavy involvement in Missouri plan type situations. But and obviously, even among those states that have Missouri type plans, they're all a little different on how they're run. So I hesitate to speak in generalities, but I guess the normative issue would be is it good or bad to kind of flat out prohibit interest groups from formally testifying like it is for the lower federal courts and nomination process. And I guess the realist might say, well, that's just going to drive interest group activity in other ways if you ban it, so to speak. In one area, it's going to lead, it simply will, imagine I'm looking up Michael Dimino here, he would say it's, almost self-defeating, or be careful what you wish for, it'll simply lead it, in other ways. I would imagine he thinks that's probably a bad idea anyway on its own terms. But
yeah, you might ask what the problem is why we want to exclude them from the process.
I am under strict orders to end at 10, and it's now 3 after. So we will continue